Mr. Forenza said something about special appearance, not a general appearance. I don't know what he was trying to say. Mr. Fitzgerald, what would you like to do today, sir? I know you're covering.
And I object to this right now. I do not consent to this hearing.
All right, I need you to stop talking or you're going to be removed from the courtroom. This is your one and only warning. You have a lawyer. He does the talking for you. We're not doing this, Mr.
I'm
Forenza.
terminating my lawyer.
Okay, we can talk about that on another day. Mr. Fitzgerald, sounds like he doesn't want to have counsel.
I can tell the court that we asked the court to bring up the question of my client's bond. He said on a $250,000 bond, and we had asked to have a reduction. Obviously, he doesn't want to see us move forward, but I do believe that I have to advise the court as to our basis for the motion.
But we also have the complication of Mr. Forenza saying that he doesn't want to have counsel. So sounds like we should probably just set this for a hearing in the not too distant future, Wednesday the 15th at 4 p.m. So Mr. Forenza, I assume someone from from one of your attorneys will be in touch with you here in the not too distant future.
I haven't heard from my attorney at all.
Okay.
That's effectiveness of counsel.
Okay.
Also, I still don't know the nature and cause of the crime. I have no probable cause, nothing, being held 97 days without nothing.
Okay.
Violation.
Sure. So Wednesday the 15th at 4 p.m. If you want to fire your attorneys, that's totally within your right. You hired them. And then you'd be automatically eligible for the public defender, given that you're in custody.
They're in conspiracy with the DA. I also have proof of that. So
okay, well, that is proof that I think would be really important to show to a number of different authorities. So Wednesday, July 15th, 4 p.m. Well, for status of counsel, perhaps bond. We'll see everyone then. Bye-bye.
Thank you.
Thank you, Your Honor.
Relinquish all powers of attorney.
Again, I don't know what that means. In the Forenza matter, this is 26 CR 299. He's in person in custody. His lawyer, Ms. Geisinger, appears via WebEx for the moment. Ms. Geisinger, can you hear me? Ms. Bauer is here for the people. Ms. Geisinger, I can see that you unmuted yourself. Can you hear me? No, now you've muted yourself again.
I object, Your Honor.
No, you can't. Stop talking.
Article 3.
I'm not talking to you, sir. When I am done talking to your lawyer, I will find out what the next steps are. Ms. Geisinger.
I'm here, Your Honor.
Okay, Ms. Geisinger, good afternoon.
Good afternoon.
So we're here on the record in the case that I've already called. Mr. Forenza is in person in custody. He's suggested last week that he wanted to discharge you as counsel of record. You filed a motion to withdraw that you indicated was unopposed. I got it yesterday. I didn't want to grant it until I heard from Mr. Forenza specifically about that mention of it being unopposed. So I'm going to give Mr. Forenza a chance to tell me, do you object or not object to your counsel withdrawing?
I want her to withdraw.
Okay. All right. I'll go ahead and grant the request for privately retained counsel, Ms. Geisinger, to withdraw. Thank you for showing up today. See you when we see you, Ms. Geisinger.
Thank you, Your Honor. You have a great day.
You too. Bye-bye. Okay. Mr. Forenza, what do you want to do for an attorney, sir?
Oh, I have a right to represent myself.
Okay. So I've got some questions for you. We've got to go through these questions before I can decide whether you can represent yourself.
Object, because you cannot make a determination on my behalf.
Okay. So, Mr. Forenza.
I'm here by limited special appearance. I don't waive any rights. I challenge jurisdiction, all jurisdiction, and I want to establish, demand established on the record before moving forward any proceedings.
Okay. Mr. Forenza.
And I preserve the record for appellant.
Mr. Forenza, do you understand that you have a right to be represented by counsel throughout these proceedings?
I understand my rights, Your Honor.
Okay. Do you understand that right, though?
I understand my rights, Your Honor.
Do you understand that right?
I understand I have a right to counsel.
Thank you. And I'm going to tell you, sir, that we can play this game. You're welcome.
Your Honor.
No, stop. Let me finish. You are welcome to do this. You can file papers about jurisdiction. You can file papers about anything you want. And I'm going to look at them. I'm going to give the DA a chance to respond, and I'm going to issue orders. That's how this is going to work. But today, right now, if I can't get through this, then I can't determine whether you can represent yourself. That's the law in the state of Colorado. Whether you agree with it or not, that's not my problem.
That's a violation of my rights.
Okay. I have a fundamental belief that I have to follow the law, and that's what I'm going to do. If you disagree,
laws or
that's
statutes,
great.
Your Honor. I'm challenging every jurisdiction. I'm challenging everything that you do.
Great.
That the DA does. I have not been, I have no nature and cause. I have no probable cause. I'm being unlawfully detained.
You're going to go
I know.
back into the jail if you can't follow my directives. That's exactly what's going to, and we're going to keep doing this day in and day out
Article 3,
until
Your Honor.
Article 3 what?
Subsection 1, you're supposed to be in
Of
good behavior.
what?
Of the Constitution,
Which Constitution?
not the state. The United States Constitution.
I'm an Article 3 judge?
No, you're not Article 3. Under Article 3.
Okay. Sir, do you understand you have the right to be represented by an attorney throughout these proceedings?
I do understand.
Okay. Do you understand that if you can't afford an attorney, and because of your status as an incarcerated individual, that you automatically qualify for the appointment of court-appointed counsel? Do you understand that?
Understand.
Okay. Do you understand that I would appoint an attorney to represent you if you wanted me to? Do you understand that?
I do understand, but I do not accept, and I will challenge that.
Okay. I'm in a position of trust, 2 counts, both of which are class 4 felonies. Those particular charges carry with them the possibility of 2 to 6 years to life in the Department of Corrections, followed by an indeterminate period of parole. There's the possibility of those particular charges. I'm not sure if they're extraordinary risk crimes, but if they are, then Ms. Bauer?
Yes, it's 2 to 12 to life. They are extraordinary risk.
Okay, so then the possible penalties are 2 to 12 to life in the Department of Corrections. And what that means, Mr. Forenza, to break it down in somewhat more layman's terms, is if you were convicted either by plea or at trial, it would be a sentence, it could be a sentence of any number between 2 years and 12 years, and then it would be up to the remainder of your natural life. Again, Ms. Bauer, please correct me if I'm wrong, but I think that one would be 10 years to 32 years to life? No?
That is the 8 to 24.
8 to 24 to life.
Yes.
So that's also an extraordinary risk crime. These particular statutes, crimes, sir, have unique penalties in the law. So I'm trying to make sure I get it right. That's 8 to 24 to life, followed again by that indeterminate period of parole. It would be 20 years to life of parole, to be exact. So do you understand the possible penalties?
I do understand possible penalties.
Okay. You're not waiving any rights by answering these questions. You're not waiving jurisdiction. You've already objected to that. That's all on the record. Everything's recorded.
I do challenge jurisdiction.
I understand. No, you already said that. You don't have to keep repeating it. Do you have any legal training, sir? Like, have you gone to law school? Did you go to college, get some legal training in college, taken some classes?
I'm a certified law professional
A certified law professional. What does that mean?
under a Constitution and international level. I don't practice state law because of statutory codes. Rodriguez versus Ray Donovan, all statutes are unconstitutional according to the Constitution.
Okay.
So I stay away from your statutory,
So you claim you have some legal training?
sir.
Okay. Did you go to law school?
No, I was going to apply, but I decided not to. I understand that the legalese that is used is basically doesn't make sense to our rights, and it's a whole different ballgame.
Okay.
I understand where it's derived from also too. I studied that.
Great. Did you go to college?
I have.
Where did you graduate from college?
I graduated from ITT Technical Institute, bachelor's degree.
In what?
Information security cyber specialist.
Okay. So you're a high school graduated from college, have some legal training. Are you not under the influence of any alcohol, drugs, or medication that may negatively affect your ability to think clearly here today?
Well, obviously, I'm in torture cuffs and unlawfully detained, so no alcohol, no drugs.
Okay. Believe it or not, sometimes folks manage to get a hold of those things in jail, but
I don't drink, I don't do that stuff.
great. Do you want to consult with the public defender, not as an appointment, but just to talk to them?
I would be waiving my rights and giving up jurisdiction.
It would not be waiving your rights. It would not be giving up jurisdiction. It would simply be consulting with the public defender before you make this decision.
No, sir.
Okay. Do you understand that criminal law is a remarkably complicated area, that folks like Ms. Bauer have been doing this longer than I have. They've gone to law school. They've practiced law for many years. They've had to take a test, pass a bar exam. It's complicated. It's not easy. Do you understand that?
I do understand that I'm being deprived free access to the courts and law to defend myself. And there's no resources for us here, and that's a violation. Okay, I do understand that.
Okay.
So had I have more stuff to do what I have to do, and discovery, and also Brady content, extrinsic, intrinsic evidence, everything, I would be able to fight my case.
Okay.
But I'm being dragged through this with nothing. So I've been unlawfully detained for 104 days now with nothing.
Okay.
You think that's fair? That's unfair trial.
Okay. So do you understand that criminal law is a complicated field?
I do understand it's complicated.
Okay. Do you understand that you have the right to confront, cross-examine witnesses, put on evidence in your own defense, demand a trial before a jury or a judge?
That's correct, and face to face.
Okay. And do you understand you have the right to subpoena witnesses to compel them to testify on your behalf or as part of your case?
That's correct, sir, but it's hard when I'm here and I have no resources to do that. So again, it's one-sided and the thumb is on the scale.
Okay. There's a distinct possibility that there's no going back.
I do understand. I'm fighting for my right, my life and my rights.
Right. And you understand that by doing so, without counsel representing you, without the public defender, without privately retained counsel, that you take a great risk of not doing this right.
I take a great risk with counsel, and I do understand the risks involved. But
Tell me what the risks involved are.
not being provided the essential elements to the case
Okay.
can defend it. 104 days, you know what I could have done with that? I've had my property stolen by these guys. I've had money stolen, my life stolen, and this goes farther back than this from Mesa County.
Yeah.
So there's a lot more involved in this than just this. I've been stripped of my life, liberty, and property.
So going back to the consequences that you're looking at, you talked about the 104 days you spent in jail. I told you a few moments ago, if you were convicted at trial, the ultimate consequence here could be the rest of your life incarcerated.
That's correct.
And you want to run the risk of trying to represent yourself, thinking you're going to do it better than anyone else who could assist you, period.
Your Honor, this is the racketeering system here. I've talked and I've interviewed many people here, and it's the same thing with the public defenders. You put excessive bails. You just go to extreme, taking their life away. And I understand there's certain consequences. Yes, you have to do what you have to do. But I'm hearing the stories. I've learned a lot here.
Yeah.
I've learned a lot. A lot's going to be exposed.
Okay.
So what me going with an attorney is going to be no different than me doing it myself.
Okay.
I've had an attorney I paid for, and effective counsel, they don't even call me. I tell them I need this done, that done. They don't even do it.
Okay.
So how is that even worth wasting my time with?
So I don't know. I can't tell you the answer to that question. I mean, that was a privately retained attorney, whether it was privately retained or not. I don't know that I could answer the question,
With
but
defenders, Your Honor, I get them and they go behind my back, and I find out I'm not going to go because I'm going to be filing on that, but stuff that happened.
okay.
This is an injustice system.
Okay.
There's no fairness here. I'm not going to have a fair trial. There's not going to be an impartial jury. I've been slandered all over the U.S., the internet. So how are you going to have a jury come in and sit now on my case? It's your duty to make sure that that doesn't happen.
Right.
It's beyond that.
Yeah.
It's beyond that.
It is my job to make sure you get a fair and impartial jury, and I will make sure that happens if and when we get to that point. It's also my job to try and advise you against making I don't know that it's my job to advise you, but it is my job to tell you that you make a great chance of making a mistake by choosing to represent yourself. But I don't know that I'm going to be able to really impart that upon you any more than I have already done so, especially when you have as much on the line as you do. You've convinced yourself that you can do it better. So,
Your Honor, if you don't mind.
sure,
So,
I might mind.
the excessive bail.
Yeah, we're not talking about bail.
No,
And I didn't set your bail, by the way. I just upheld it when we had a bail
But
hearing.
the prosecution fabricated, they didn't produce any evidence to me, submitted to me, and they used content that shouldn't even been in there, basically saying that I'm a threat to the public. Well, if this is back in 2010, 2011, I've been,
Remember, you have the right to remain silent.
right, but there's nothing else. I've done nothing.
Well, I think at your bail hearing, I mentioned that there was a prior case in this courthouse, so somebody
It was dismissed.
right.
Right, and it was, federal court had jurisdiction, Your Honor, and that's why Mr. Groton didn't want to accept that. So he unlawfully had me detained, okay, which is a violation. So it wasn't I didn't show up. I came there, I filed on the record with the court, and I also appeared and to verbally tell him.
And what happened when you did that?
He got mad.
Oh, he got mad. Okay.
He got very mad. So it wasn't like I was running, and it wasn't like I was trying to just not show up. No, I was performing to the contracts, and now they're dismissed. So I'm not a threat. If I could be released to go do what I have to do, I mean, my finances, my credit shot. I mean, talking about unusual punishment, this is it. It's destroyed my life, my reputation. I would just like to get out there so I can get my stuff together and do what I have to do to come in here to fight this, because there's a lot more to this than what they know.
Okay.
And my evidence has been taken from me.
All right.
There's a lot more to this than, trust me, it goes farther than this.
All right. Well, like I said, if you think you're going to be able to do it better yourself from the position that you're situated in the Mesa County Detention Facility than an attorney representing you, advocating on your behalf, then that's your choice.
In this courtroom hearing, the defendant repeatedly challenges the court's authority, refuses to cooperate, and insists that the judge has no jurisdiction over him. Despite multiple interruptions, the judge remains calm and explains that the defendant's attorney speaks on his behalf and warns him that continued disruptions could result in his removal from the courtroom. The defendant then dismisses his privately hired attorney, and the judge grants the lawyer's request to withdraw. Before allowing the defendant to represent himself, the judge carefully questions him to ensure he understands the serious consequences of waiving his right to legal counsel. Throughout the hearing, the defendant repeatedly claims he is being held unlawfully, challenges the court's jurisdiction, and argues that attorneys and prosecutors are part of a conspiracy against him. The judge patiently explains the complex felony charges, the possibility of a lengthy prison sentence, and the risks of self-representation, emphasizing that criminal law is highly complicated and that representing himself could have life-changing consequences. Although the defendant insists he can defend himself better than any attorney and continues to complain about unfair treatment, excessive bail, and violations of his rights, the judge remains professional, reminding him that the court's duty is to ensure a fair trial while strongly warning against proceeding without legal representation. The hearing ends with the defendant still determined to represent himself despite the judge's repeated advice.